So what is a living trust?
A living trust is a legal document you make while you're alive to take care of you, your family, and your property if you become incapacitated or pass away.
When is it too late to have a living trust?
Well, it's too late to make one if you're totally incapacitated, like if someone has dementia. The law requires someone to know what they're doing when they make a trust. That's what we call legal capacity. And of course, it's too late to make one if you're deceased.
Okay. If I have a trust and I bring it to you, is it garbage? Am I going to have to start over?
No, not necessarily. We would sit down and have a discussion about what you're trying to accomplish, but in some cases we can do an amendment to the trust, which is just a process where you're changing part of it. Or in other cases, if you have substantial changes, we might do a restatement of the trust, which would be a total replacement, but you're going to be able to use parts of your existing estate plan, even in the worst case scenario. The difference between a revocable trust and an irrevocable trust, the major difference is you can't change as much of the irrevocable trust as you can with the revocable trust. So even though a trust is irrevocable, there's often parts of it that can still be changed. In a revocable trust, that's the type of trust that can be completely changed and completely canceled. There are different types of irrevocable trusts, but they're done for larger estates for estate tax planning, and they're also done a lot for long-term care, nursing home protection planning. The parts of those trusts that typically can be changed is who the trustee is. So if you appoint your son or daughter or a bank and you want to change that in the future, that's something that can be changed in an irrevocable trust. Also in an irrevocable trust, even though assets or accounts have been put into the trust, let's say you have your account with a big financial institution and you want to move it to another, you can still do that. So your assets are not locked in a particular type of ownership. They can be changed within the trust. They just have to remain in the trust in most cases. And finally, another major area of the irrevocable trust that can be changed is who the ultimate beneficiaries are when you pass away. When you create those types of trusts, you often retain the right to change that. So if one child is extremely financially successful, maybe they don't need the money as much, maybe another child isn't in that situation and they need it more, you could make those sorts of adjustments in the future.
Even if you write an irrevocable trust, you still reserve the right to make changes to it, even though it's irrevocable.
Correct. In most cases, you're going to be able to change those types of provisions in an irrevocable trust.
That's good. When would you make an irrevocable trust?
These days, mostly in two different situations. One would be if they're concerned about depleting their estate from long-term care or nursing home costs. The law allows people to make what we call a Medicaid asset protection trust, which is an irrevocable trust. You can put some of your assets or accounts into that trust, and if 5 years pass after doing that, those assets are not at risk to having to be spent down to qualify for nursing home benefits. The other broad area is a different situation when someone has a very large estate where they would be subject to estate taxes if they pass away. Typically for a single person, we're not going to be concerned about that until they're above 5 million or so, and for a married couple above 10 million. But there's different types of irrevocable trusts that can be used there to get assets out of your estate so the government doesn't apply the estate tax to them when you pass away.
So let's get into some of the technicals of different types of planning and the different options that you can create with those different methods.
With the estate plan and long-term care planning, there's a few ways to approach this too. So the ideal way might be in someone's revocable living trust. A problem I see with a lot of these trusts that are drafted by attorneys is it just says that if I become incapacitated, my trustee should use my assets for my health, education, maintenance, and support. Well, often when people are, 85, they're not really concerned about furthering their education at that point if they're incapacitated. So that's kind of a provision that doesn't have a lot of effect. And there's really no definition of what it means to maintain or support someone if they're incapacitated other than just paying their bills. So if I have a client who has followed my advice and looked into getting one of those hybrid or asset-based long-term care policies, often we're not going to have to worry about them depleting their estate on long-term care because they've already taken care of that. So in that case, we would want to include in their living trust, there's going to be a section that describes what the trustee, the person who's acting on their behalf, should do if they're incapacitated. So we would put in there that I've got this policy that can help pay for my care. I don't want you to put me into a nursing home. I don't want to go to a Medicaid nursing home where I have a roommate, someone I've never met before. I want to be taken care of in my home, and you can use this policy to pay for it. We won't have to worry about depleting the estate because it's already taken care of. The trust would also say, because sometimes people, their dementia is so bad where they can't be left alone, or they just need such a medical level of care that they maybe do need to be in some type of long-term care facility. So the trust could be drafted to say, my trustee can admit me to like an assisted living facility to help pay for my care or take care of me. But my trustee should make sure I'm being taken care of there. They can use some of these funds from the long-term care policy to maybe hire a nurse to check on me monthly or weekly, whatever the case may be. So one plan might be keep me out of facilities as long as possible, as long as it's reasonable to do that, because I've already taken care of how to pay for it. Another way to approach it is not everyone will want to get one of these policies, or they may not have enough money to do so. So there we have to be more concerned about protecting their estate from a Medicaid spend down. So for a married couple, there are provisions we can build into a living trust to protect maybe half or part of the estate, or maybe more in some cases, for the surviving spouse. It's really technical, so I won't go into lots of detail here, but people should know that a living trust, there are provisions that can be built into it to protect against long-term care.
What are some ways that the trustee or the caretaker for the trust can miss things or make mistakes?
Mistakes that a trustee can make happen often when usually their parent has either become incapacitated and they're for a long period of time and the trustee is paying their bills and handling their money for them, or they're trying to settle the estate when they pass away. So unfortunately, there are lots of probate litigation cases that occur all the time when a trustee doesn't do their job well. When someone has a trust and they have become incapacitated or pass away, the trustee becomes a fiduciary, which means they have to act in the best interest of the trust and the people who are involved in the trust. So some people just don't have that personality. That means they're supposed to, being a fiduciary means they're supposed to be reasonable. They're supposed to learn about the ramifications of a decision before they make it, not act hastily or act impulsively. And it means they're supposed to be fair. So sometimes people have a personality where they think the trustee, being the trustee, means that they're totally in charge and they don't have to listen to anyone else and they can act on their own timetable. But when someone's a trustee, the law generally requires them to settle the trust in a reasonable amount of time, make prudent decisions. So that means they can't sell the property up north to themselves for $50 when it's worth $200,000 and things like that. And it also means they have to keep the other beneficiaries informed about what's going on in the estate. They have to do a report. So even though we're not in court, in a probate court settling an estate there, the trustee still has legal responsibilities they need to follow that often they're not aware of because there's not a court involved telling them that.
Mm-hmm. That's good. What's the difference between an attorney who can do a will or can do a trust and they do it every single day or they specialize in it?
The difference between an attorney who just dabbles in estate planning or specializes or focuses in it is big. As an attorney, once I passed the bar, I could handle a murder trial this week, a big business litigation lawsuit next week, and then I could do your trust the following week. But that's not really going to produce the best result because each area of law has become so specialized and focused. Someone needs to spend most of their time counseling people in these areas and staying up on the law. Every week there's new case law issued and written reports that we need to study to see how the courts are interpreting the laws the state legislature has passed in probate and taxes and long-term care and incapacity planning. So if an attorney is focused on estate planning where they're doing elder law and estate planning every day, they're going to know how to apply all this experience to your situation. So it's kind of like going to a doctor who's been practicing for 10 or 20 years. They're going to be able to make a diagnosis that's accurate much faster than someone who's a generalist or just getting started in it.